does the defense intend to call any additional witnesses?
The defense does not, Your Honor. The defense would rest.
The state intends to
May I have a moment, Your Honor?
Certainly.
Your Honor, state has no further witnesses. State rests.
All right. So no rebuttal.
Your Honor, at some point may the jury be excused for legal arguments.
Certainly. All right. At this point in time, I am actually going to I should send the jury. Do you want me to send the jury home at this point? Or?
That's fine.
No objection, Your Honor.
All right. So the court is going to release the jury for today. Okay. So I just want to remind you that we are at the part of the trial where you have heard all of the evidence that you're going to hear in this case. However, you've not yet heard closing arguments. You've not yet heard the instructions regarding the law that you're to apply to the facts you find in this case. As such, as in my prior instruction to you on your oath, you're not at a point where you can discuss this case with anyone, including each other. So you're not at that point yet, despite the fact that you've heard all the evidence. So it may seem natural that you are at the phase where you can talk about this with your fellow jurors, but you cannot, all right? So you need to continue to abide by that instruction until such time that I tell you that you are able to go ahead and conduct your deliberations. So we are going to adjourn with respect to the jury right now for the day. You are able to leave. Again, we will not be having court on this matter tomorrow, and next to you on July 3rd, at which time I would anticipate closing arguments and the instructions, and then thereafter deliberations by you, the jury. Okay, so please, again, remember not to discuss the case with anyone. Do not take in any information about this case. Try to avoid the media as best as you can. There is a lot of media attention on this case that includes social media and news coverage. So if you can please avoid those, or would much appreciate it so that we don't have to deal with any conflicts when you come back. Also, again, there have been locations that have been discussed. Do not do any drive-bys. Do not look up any locations via any other type of mapping device. And last but not least, please do not conduct your own independent research or investigation into this case, because you are going to be instructed to decide this case based solely on the evidence presented here in this courtroom. With that, have a good afternoon. Have a good day tomorrow, and we will see you back on Thursday. Thank you so much for your continued attention. Attorney Smith, you wanted to present legal argument.
Yes, Your Honor. At this point, we would move for a motion of judgment of acquittal under Practice Book 42-42. The state's evidence has closed. We made our motion at that time. We've now heard from Mr. Valle, and I would renew my motion, and I would direct the court to the cases of State versus Carpenter, 214 Con 77. It's a 1992 case, and State versus Thomas, 210 Con 199, a 1989 case. And the standard here is well known to the court. This is to be viewed in the light most favorable to the state. But even when viewing that light, viewed in that light, this evidence is insufficient for this jury or any jury to find beyond a reasonable doubt that Mr. Valle had the specific intent to murder anyone, that Mr. Valle had the specific intent to assault Tommy Connery or to assault Ryan Hines, and more so even With regard to Mr. Faison Teal, which is the assault in the second-degree charge, the evidence as to Mr. Teal, candidly, is we heard the least about it. We really don't have any indication of what the mechanism was. Mr. Teal couldn't be sure how he got cut or what exactly it was that cut him, and we haven't heard any evidence of anybody viewing that happening. And so it has to be simply an inference that a juror would draw that in the course of this brawl and this chaotic scene, that somehow Mr. Valle cut Mr. Teal. I would submit that that is an inference that is unreasonable to draw on this evidence that we have before us. Specific intent is not simply general intent. So the fact that Mr. Valle has testified here that he was flailing around with the knife trying to defend himself is not sufficient to show the specific intent to stab Tommy Connery, the specific intent to stab Faison Teal, or the specific intent to stab Ryan Hines, or the specific intent to stab Jimmy McGrath. As to the other elements, candidly, we have conceded those elements by raising a self-defense claim. That doesn't, however, mean that the state prevails, even when you view this evidence in the light most favorable to the state. That they have shown beyond a reasonable doubt for these fact finders that Mr. Valle possessed the specific intent to murder or to assault any of the injured in this case. Consequences are tragic, but it simply doesn't tip the scales any further and allow this jury or any other jury to find, again, that the state has proven specific intent. The evidence there is equivocal at best, but in no way does it reach that highest standard and overcome it. We would ask the court to grant the motion for judgment of acquittal as to all the charges.
Attorney Giuseppe.
Your Honor, thank you. I would just first start by saying the defendant has testified and is now subject to the same credibility instruction that every other witness is subject to when you charge the jury. The jury is free to believe all, some, or none of the defendant's testimony, and that's up to the jury. I would submit that there are a lot of inconsistencies in the defendant's testimony, and I would submit that the defendant was caught in a lie multiple times in his testimony. And I would submit that that would have an impact on this jury. With regards to the defendant's specific intent, should the jury believe that the defendant went back there with a knife, his intent was purposeful, and that he took that knife out of his right pocket, opened it up, and started stabbing the people that were before him. There was evidence that Faison Teal, Ryan Hines, and Tommy Connery were in the vicinity of where Mr. Valle was. He stabbed Ryan Hines and Faison Teal first. They were stab wounds, not slashes. So the jury can infer from the circumstantial evidence from Faison Teal that his wound was a stab wound, purposeful, not slash. There was some testimony from doctors with regards to that. The jury could also view Mr. Hines' evidence that he was stabbed purposefully this way, not a slash wound or flailing around. The jury can infer the defendant's intent from that. With regards to Tommy Connery, there was evidence that the defendant was down almost on one knee, that he purposefully went at Tommy Connery and stabbed him 4 times in the leg. And with regards to Jimmy, after he came back from the car, when Mr. De Silva was no longer in harm's way, he turned right at Jimmy and purposefully went at him and stabbed him in the heart. Didn't slash him, stabbed him. I would submit that the jury's going to get an instruction that intent can be formed in an instant. And they could also infer from the circumstantial evidence, should they not believe the defendant's testimony, that the number of wounds inflicted, the area of the bodies where the wounds were inflicted, all points to the specific intent of the defendant on May 14th of 2022. So I think when you view all the evidence in the light most favorable to the state, Your Honor, I think the defendant's argument fails, and I would ask that you deny it at this point.
So this motion being made at the close of evidence in accordance with our rules of practice, the court is going to take the motion under consideration and defer a decision until the jury returns its verdict. So again, there won't be any court proceedings tomorrow on this particular matter, and we will see everyone back on Thursday, July 3rd. I would instruct counsel, please, at some point, just to touch base with me for an informal charging conference. I intend to be on the record on July 3rd. In the morning, we'll start with the formal charging conference on the record, at which point in time thereafter we'll move to closing arguments, and then the court will charge the jury.
Very good, Your Honor.
Thank you, Your Honor.
Thank you. Court stands adjourned.
All rise.